Before we start this afternoon, can I just correct something for the transcript and for everyone that's listening? I was asking Mr. Lister about a document, a submission that was sent to Yvette Cooper. We don't need to look at it, but it's DHSC 0041379_177. And I asked why did that go to Yvette Cooper rather than the Secretary of State? It was given that it was a submission about the HCV compensation scheme. And it's been pointed out to me that it was addressed to Yvette Cooper, but also to the Secretary of State. So I just wanted to make that clear. And the second thing, before I ask you some questions about VCJD and recombinant, Mr. Lister, is I understand that you've been reflecting over lunch about one of the questions I asked you before lunch and would like to update us on your reflections, if I can put it that way.
Yes, you asked me why I thought ministers refused the idea of a compensation scheme, and I was trying to think back to the context of that period, the new Labour administration, that ministers at that time were having to take some very, very difficult decisions about priorities on public spending. The Blair administration decided for its first 2 years that it was going to retain the previous government's spending limits, so that by 1999, I think public spending was at the lowest since the early 60s. But at the same time, the NHS was in major difficulty. There were a big crisis over waiting times. I mean, far too many people were dying because they were on waiting lists. And it was one of those issues that ministers were determined to tackle, and there were a lot of other issues as well around poor outcomes for people with heart disease, poor outcomes for people with cancer. And I think trying to put myself in the shoes of ministers at that time, their overwhelming priority was to improve those critical frontline NHS services. So they were constantly having to decide whether to fund something that would take money away from those frontline services or not. And I think that's the context you probably have to think about ministers' deliberations on this. Do I take money for a compensation scheme away from the money that would otherwise go into frontline NHS services? And my feeling is that that would have been, what was upmost in their mind.
Now I'm going to ask you some questions about VCJD, but can you help us understand this? We see in the records, obviously we know about you were in the blood policy team, but we see in the records references to a CJD team. Was there a CJD team at the time that you were in the blood policy unit?
There was, yes. That was headed by Dr. White. So she would have been responsible for all the issues around variant CJD and tracking that with Dr. Will's CJD surveillance unit. And it was that unit as well that was responsible for setting up the Cjd Incidence Panel, chaired by Professor Banner, that looked at the whole issue of people potentially exposed to variant CJD through surgical instruments and through blood. So yes, there was a separate CJD unit.
And so what was your responsibility for VCJD? How was that defined?
Right. I should also say that unit would also have been the secretariat for for SEAC as well. So Alan Harvey, who I corresponded with a lot, was part of that team as secretary to SEAC. The distinction was that I was looking at the whole question of variant CJD risk in blood, and in particular the risk reduction measures that had already started to be introduced at the point that I joined. So the Medicine Commission's decision to decide that we should no longer be using UK source plasma for plasma-based products, and the decision to leukodeplete blood for transfusion.
And so, as you say, those two key decisions had already been made by the time you arrived, but
Had not yet been fully implemented.
Indeed. And it's also right to understand is that UK plasma was still being used for FFP, fresh frozen plasma.
It was, yes. The distinction being that fresh frozen plasma was single from a single donor, as opposed to pooled plasma products from many thousands of donors. And I think the issue was about the lack of availability of alternatives, initially at least.
And at some point during your time at the Blood Policy Unit, a decision was made to buy a US manufacturer of plasma, or collector of plasma, I should say, Life Resources Incorporated. Can you tell us a little bit about why that decision was taken?
Yes, I can. So after the decision was taken to stop the collection of UK donor plasma, the Bioproducts Laboratory had to find alternative sources of plasma and contracted with various providers, all in the US, where there'd been no cases of BSE, to supply bulk plasma for fractionation. In 2001, the Bioproducts Laboratory learnt that those contracts, or at least two of the biggest contracts, were going to be withdrawn. There was a notice period. It was maybe 12 or 18 months, something like that. But we recognised that we were facing a crisis, that potentially there would be no or hardly any supply of plasma for fractionation coming into BPL for the products it was manufacturing. So we had to address that crisis. One of the key drivers on that was around intravenous immunoglobulin, which is one of the products manufactured by BPL, for which there was generally a shortage on the international market. So the option, for example, of simply buying in product rather than manufacturing it in the UK was one that we looked at and rejected as high risk. So at that time, one of the other things that was happening that had precipitated the withdrawal of contracts were that multinational pharmaceutical companies were buying up the plasma collectors in the US, taking them into their own ownership, and because they wanted to secure those supplies for themselves against shortages in the market. And I simply thought, well, why can't the British government do the same? And I think fairly recent to that, there had been changes in the law which would allow the UK government to take a private company into ownership. And given that, I made the proposal to the Secretary of State in, I think it was July of 2001, that we consider the purchase of this company, Life Resources Incorporated, which had already been a supplier to BPL, which was in private ownership, which was at risk of being bought up by the multinationals, and we knew that the owner who was coming up, who was getting to a point where he wanted to retire, would be interested in selling. So that was the sort of background to it all. We didn't go straight into that. I mean, that was the option that we were looking at, but the main option, but we also then investigated a whole series of other alternatives for securing bulk plasma for BPL to fractionate, and went through a series of options most of which were looking at the US market because nowhere else supplied the quantity of plasma that BPL would need. But we came down in the end to the purchase of Life Resources Incorporated being the only way of securing the supplies of plasma we needed, at the safety level we needed, and the quantity we needed.
And is it right to understand that you spent quite a significant amount of your time on the purchase of Life Resources Inc.?
Yes, so there was a lot of time spent in initial discussion with the company. There was a lot of time spent looking at all those possible alternatives. And then when we decided to move ahead with the purchase of Life Resources, there was the whole process of a company acquisition. And after that, the question of how we would manage the governance of a US company from Whitehall. I didn't do that alone. I had a lot of support from the department's commercial team. They brought in consultants from KPMG to help with the company purchase. There were also an external law firm who helped with all the legal issues around all of it as well. So it was actually quite a big team, a project team that I was managing, but essentially I acted as the principal for the company purchase, attending the negotiations and communicating with ministers and with Nigel Crisp as the permanent secretary.
And that, can you recall the date when that was completed?
I think we completed it by the end of 2002, roughly. There is something, it is covered in my statement when the announcement was, but I think it was towards the end of 2002. That was happening concurrently with the negotiations on the European Blood Directive, which had started earlier in 2001 but continued into 2002. And
again, did that take up quite a lot of your time?
Yes, hugely. I was leading the UK negotiations, so I attended all the EU expert committee meetings with other member states to agree the directive, and then of course we needed to put the directive into UK law through regulation.
I'm going to ask you a couple of questions now about the notification process, and by that I mean the process by which those that had either received blood transfusions or blood products that had a plasma or blood components contributed to by somebody who had later gone on to be diagnosed with VCJD. I'm going to call them implicated products. So, but when I say implicated products, I mean the blood product has had plasma contributed to it by somebody that has VCJD. Can we go to WITN 4505071? So we can see here this is a fax from you to David Dunleavy, 1st of October 1999, about a meeting with the MBA on the 6th of October, and you say he's kindly agreed to come to the meeting and that you're attaching a minute so that before the meeting you can discuss the key issues. So we can just turn over to the minute, please, which is the next page. We can see again from you to Mr. Dunleavy, who's a solicitor, Sol C2 means the solicitor, is that right?
Yes, yes.
1st of October 1999, and you set out the background at paragraph 2, and you explain that it's been agreed that the National Blood Service will exclude from the blood supply blood donated by people who have received transfused blood from a donor who subsequently developed VCJD. There are only a small number of such people at present in this category who are the right age to give blood, and none of them are currently blood donors. And then you explain that the National Blood Service has set up a flagging system on their donor database to ensure that if those people present themselves as blood donors, a means can be devised of either deferring them, in which case donors would have to be told why, or discarding their donations, which could be seen as deception. And then you say this raises a number of legal and ethical issues which the NBA have put to their solicitors, Lebrasseur J. Tickle. And then you attach a copy of the advice and you set out what the advice is, and effectively their solicitor has taken the view that it's difficult from an ethical point of view to say that such a donor should not be told that he or she had received possibly CJD infected blood or blood products, because failing to tell the donor involves an element of deception rather than a simple considered omission. And if we could turn over the page, please, we can see why you're coming to him to advise at paragraph 6. The NBA is now looking to the department for advice on what to do. The department's current advice on this issue is set out in a circular PLCO 98, and you attach that, and that's a document that we've looked at in previous hearings.
That's the Graham Wynyard.
Indeed, so Graham Wynyard, indeed. And then you set out what that concludes. This concludes on the basis of advice from ethics experts and other advisory bodies that there is no need to inform patients who have received VCJD blood-implicated blood components because it's thought unlikely that NVCJD will be transmitted in this way. There's no diagnostic test for NVCJD, and even if a test was available, there's no preventative treatment that could be offered. And then you make the point that these statements still hold true. However, they do not necessarily override the specific legal concerns raised by Stephen Janisch in connection with the MBA. It may also be becoming harder, giving an increasing emphasis on patients' rights and a distrust of paternalism, to justify the stance that information should be withheld from patients on the grounds that it might cause unjustified worry. And then you say, in preparation for Wednesday's meeting, we would welcome your views on the specific legal issues raised. So that is your request then for legal advice. And if we can then just turn, please, to DHSC 004-1362_009, we can see the response that you received from David Dunlevy on the 5th of October 1999. And in the first big paragraph there, second sentence in brief, I think that the duty of care owed to patients extends to their being made aware of possible problems for them arising out of their treatment. Whilst the circumstances of particular individuals might excuse their being told, for example, elderly person living alone with bad nerves, I am extremely doubtful that one can lawfully have an across-the-board decision not to notify affected patients. The point is that we cannot guarantee that notification will be of no purpose whatsoever, or be sure that we would pick up the case in the future when a test or treatment had been developed. If patients are to be notified, then a further duty of care arises as to the manner in which it is done. You will note, therefore, that I think that the duty very probably requires notification to any recipients of transfusions. With regard to affected potential donors, I think it is even more difficult to see how they could be kept in the dark, given that they would surely have to be told why their blood could not be accepted. So that is the advice that you receive in advance of the meeting. And then if we could turn, please, to WITN 4505072, we can see an email, I think this is an email, from you to David Dunleavy and various other people, including Dr. Troop and Dr. McGovern, and you say, I attach a draft letter which records the outcome of our meeting on the 6th of October with members of the NBA board and executive and DH and NBA lawyers. The main conclusions were that 1, the NBA should set up immediately a system to exclude individuals from giving blood who have been identified by the NBA Cjd SU study as having received blood from people who subsequently developed VCJD. So that deals with the, and 2, that if these people present as blood donors, the NBA has a duty to tell them why it is not possible to accept their donation. And then you go on to say, given the importance of this decision, we want this letter to go off to the NBA with the minimum of delay, instructing them presumably to implement those conclusions. So with that rather long introduction, my question to you is this. Clearly the meeting dealt with the question of patients who have received implicated products turning up to the blood services to be a donor, and the meeting came to a conclusion they should be told that they've received implicated blood products. They should be notified that they are at risk, whatever the level of their risk is. What this the meeting doesn't appear to address is the point being made by David Dunleavy in his advice to you, that actually his view is that there's a duty to tell patients about their treatment, whether or not they attend for as a blood donor or not. And can you recall why the meeting didn't address that issue, given that that was the advice you'd received?
I suspect that it was because the meeting was specifically about what the NBA should do, and that question was a wider question to be addressed by the department, which, as you know, was subsequently addressed, but over a rather prolonged period.
Yes, so indeed, we can see, and you've set out in your witness statement, we can see at various different stages meetings occurring and this matter being discussed. I'm not going to take you through the chronology of that because you've set it out in a great deal of detail in your witness statement. And we've looked at some of the events in that chronology with some other witnesses. But by the time this issue having arisen reasonably early on in your time at the department, 1999, by the documents we just looked at, and we know that the notification process that the Department of Health eventually rolled out took place after you left the department.
Indeed.
So it started at the end of 2003. Can you help us with understanding, from your perspective, why it took so long?
I mean, it's difficult to do that without getting into the chronology, but the issue became one that the Cjd Incidence Panel set up, chaired by Michael Banner, who was an ethicist, which looked at this issue in relation to blood, but also in relation to treatment with surgical instruments. And they looked at it over a rather prolonged period. There was a point at which I drafted a suggested set of guidance to go out to the NHS for Pat Troop, but Michael Banner felt that there were issues with it, and so it didn't get sent. But I think for all kinds of good reasons, there were sort of constant referrals to expert after expert, and the whole thing dragged on for quite some time.
So the interim guidance that you're referring to, I think I'm not going to take you to it because we've looked at it with other witnesses.
Right.
But for the transcript, it's WITN 4505126. The inquiry's got two versions of it, one from February and I think one from May, one from February 2001 and one from May 2001. And is it right to understand that this was drafted by you because you were concerned that hospitals were effectively waiting for the Cjd Incident Panel to tell them what to do when patients came to them and said, have I received an implicated product?
Yes, there was also a concern that without guidance, individual clinicians might decide, as they did, to do their own thing, and therefore we'd have no consistency in the way in which patients were told, which didn't feel acceptable.
And so while you're waiting for the Cjd Incident Panel to hand down their advice, which would apply across the board, you thought, draft some interim guidance, but that never got issued.
No. As my witness statement says, Michael Banner thought there were serious issues with it. Though I don't think I was very clear even at the time what those issues were. He said, well, the department could send it out, but it wouldn't have our support. And after an attempt at redrafting, I think the idea was abandoned as the incident panel continued to consider the issue as part of its overall framework of advice.
One of the periods of delay that's been identified was when the Cjd Incident Panel were waiting for the chief medical officers to sign off on the what became the framework document that set out who should be notified and how that should go forward. Can you help us at all with why that period, why the chief medical officers had the document for so long?
I can't, I'm afraid. What period was that?
So it's October. It was sent to them on October 2002, and the response is June 2003.
I mean, my guess is that that would have been dealt with by the CJD team. And I don't recall anything coming across my desk about it.
Can I show you another document as well to ask a question about perhaps another reason for the delay? WITN 4505201. This is a letter dated the 26th of March 2003, and it's to Sir Liam Donaldson from Martin Gorham, the Chief Executive of the National Blood Service. And we can see in the stamp at the top, it says to Charles Lister.
Ah.
Do we understand then that would have been copied to you? Is that what that means?
Yes, I assume it would have been sent to me to draft a reply.
In fact, it looks like it's been sent by the rather old-fashioned telefax.
Yes. Actually, it was, yes, it's been sent, I see it's been sent to me by Jane Minothy, who was Martin Gorham's PA. So it's been, sent to me so that I was made aware of what had been sent to the CMO. So
right, rather than it coming via the department for you to action,
yes,
it's been sent to you for information by the National Blood Service.
Yes.
I understand. He says this: I've been instructed by my board to write to you on this topic as they are concerned about the delay in providing definitive advice to the UK blood services regarding notification. Then there's a word missing, but presumably that says 2 or 4 individuals who have been transfused with blood from donors who have subsequently developed VCJD. All these cases have been notified to the Cjd Incidence Panel, and we are still awaiting confirmed advice from this panel as to what action the blood service should take. I am aware that one of the issues is provision of adequate support mechanisms for individuals once they have been notified of their exposure. And then he goes on to say, however, our concern is a fail-safe mechanism to protect the supply of the blood, safety of the blood supply, and an important element of this safety mechanism is to inform these individuals that they should not donate blood, tissues or organs. And then he makes the point about the CJD Clinical Incidence Panel finalised guidance being available from October 2002, provided to the CMO colleagues, he says, in November 2002. And so saying that the delay in providing the UK blood services with regard to notification of exposed blood recipients being unduly prolonged. Now, you say in your witness statement that you haven't been able to trace a response to this, but what I was interested in asking you about is whether you can recall what the problem was or what the issue was about the provision of adequate support mechanisms for individuals once they'd been notified of their exposure. Was that something you would have got involved in?
Well, I assume he's probably talking about counselling services, and there was a lot of discussion over all of this period about the importance of people having access to counselling if they were given this, very devastating news potentially. So that's the issue. I'm not able to answer your question now, I'm afraid.
And in terms of whether it was your team or the CJD team who was leading from the Department of Health on the notification process, who was in the lead on that?
That would have been the CJD team, because they were responsible for everything addressed by the incidence panel.
And there's just one further document I want to ask you about in relation to VCJD, and that's DHSC 304122. Now this is a memo from Howard Roberts, who appears to be a solicitor, 5th of March 2001, to A. Harvey, who I think you said was in the CJD team.
Yes, that's Alan Harvey, absolutely, yes.
And you've been copied in.
Mm-hmm.
And it's in relation to legal advice on the system that was being used by the National Blood Authority, the flagging system. So we can see there at paragraph 2, in your minute you ask about the legality of passing on patient information about VCJD to a central registry. The short answer is that the only safe basis in law for passing on such information is informed patient consent. Ministers have also expressed their view that informed consent should these days be the norm for information sent to registries, as well as for other purposes which are not directly related to the treatment and care of the patient in question. And then it goes on to make some points in paragraph 3 about the increasingly strict construal of the doctrine of implied consent. And then make some points about the fact that the law may be changing. And then over the page, the advice is given in paragraphs 5 and 6. Second sentence, first sentence, until the new power is enacted, we need to consider the 3 principal legal constraints on disclosing information, and then goes on to set out what those are. And the conclusion at paragraph 6, under the law as it stands, in my opinion, particular disclosures might, depending on the facts, be defended. But a general policy of disclosure without consent would present unacceptable legal risks. Now, I just want to ask you, I'm conscious this is a legal advice that was not given to your unit, it was given to the CJD team. I'm also conscious that this was in respect of a system that the NBA were operating, the National Blood Authority, not the Department of Health, albeit it was on the Department of Health's direction. Do you know whether or not any steps were taken by the department following receipt of this advice?
I don't recall at all, I'm afraid.
And do you know, and you may not know the answer to this, but do you understand that the system, the NBA flagging system, continued to operate during your time at the Blood Policy Unit?
Yes.
I'm going to turn now to ask you some questions about recombinant factor products. Is this right that in England, at any rate, when you took up your role at the Blood Policy Unit, a recombinant factor 8 was available for those under the age of 16 and to new patients?
That's correct, yes.
And what was the position in Scotland and Wales, you recall?
I can't at that point in time. Scotland was certainly ahead of England in the provision of recombinant, and they've certainly provided recombinant for everyone before we did in England. I think Wales similarly. But yes, at the time I joined, it was only available for patients under 16, although with the assumption that when they got beyond the age of 16, they would continue receiving it.
And is it also right to understand that your position was always that England should adopt recombinant factor products for all adults?
I think from fairly early on, yes.
And why did you come to that view?
I came to that view particularly after all the concerns were raised about variant CJD. So it felt that although we had dealt with the issues around HIV and hepatitis C and blood products were free from those risks, that variant CJD indicated that there was this potential for new risks that hadn't been anticipated through human-sourced plasma. So with the availability of recombinant products, it felt only right that we should look to provide those for all patients. The question, as ever, was about both the availability of the product, and there was a question about whether enough product was available for all patients in England, and also the cost, bearing in mind that there were first and second generation products on the market and the prospect of a third generation entirely albumin-free product, each of which was more expensive than the other.
You've set out in detail in your second witness statement the steps that were taken through your tenure at the Blood Policy Unit in relation to recombinant factor, and I'm not going to go through those. I'll just summarise them as a sort of introduction to my next question. That you were advising ministers from January 2001 that there ought to be a phased introduction of recombinant factor 8 over 4 to 5 years, and that was accepted by Alan Milburn at the end of February 2001. Mm-hmm. But initially the funds couldn't be found. Is that right?
If I remember correctly, the suggestion was from Alan. Well, I think we had suggested possibly that the NHS might fund this directly. I think for the reasons I mentioned at the start of this discussion, Alan Milburn said no to that. The other possibility was that the money for it could be found within my directorate's existing spending, but that was not possible either. So that left us ultimately with not being able to do anything until we could bid for funding through the next spending review round, which was the 2002 round.
And that was a successful bid, which led to the February 2003 announcement that £88 million was available on a 3-year rollout. Is that right?
That's correct.
And is this right, that even then you were concerned that that was actually not enough money for the 3-year rollout?
Yes.
And why was that?
I think that was largely to do with the cost of third-generation products. We were relying a great deal as well on trying to get reductions in the price, the unit cost, through bulk buying. And I was working with the NHS Purchasing and Supply Agency for some months leading up to that to see if we could get the price down. But I think there was a concern certainly that with rising costs and that we it might not be enough.
And then in order to roll the programme out amongst patient groups, you formed a working party, is that correct?
That's correct.
And that was to look at the contracting arrangements and how to allocate funds to primary care trusts, and then how to actually roll it out amongst patient groups, i.e. who should get the recombinant first, and how should it be rolled out between patient groups? Yes,
and I very much wanted patient representatives to be involved in that decision.
And so the working group consisted of members of the Haemophilia Society, the UK HCDO members, Royal College of Nursing Haemophilia Nurses Association, primary care trusts, commissioners of haemophilia services, and people from the NHS Purchasing and Supply Agency, as well as the Department of Health. Is that right?
That's right. I think we added at least one person to the membership after the first meeting, and another patient representative at the Haemophilia Society's suggestion.
So at the first meeting, no patient representatives, but then coming on for the second... Well,
apart from the Haemophilia Society themselves, yeah.
And then coming on patient representative for the second and third meeting.
Yes, that's my recollection. I think, in those days, sort of, the idea of open and collaborative government was a bit new, but it just felt to me that these weren't decisions that the Department of Health could just take without consideration of the views of those people who would be directly impacted. So
this idea of a working party to work out operationally how a Department of Health decision was going to work was a new one, was it?
It was. I had worked a good deal with the Haemophilia Society and had a very good relationship with them for some period before that, and it just seemed. It was my initiative, and it just seemed to me natural that they should be involved along with others.
And is it right to understand that process, the rolling out of the programme, had not completed by the time you left the unit?
No, we'd had 3 meetings, but it hadn't completed at all. No.
I'm going to now turn to ask you some questions about documents and destruction of documents or missing documents. I'm going to ask you about 3 different categories of documents. First of all, the papers that we've already discussed to a certain extent that you discovered were missing from the 1970s files when you were preparing your submission for Lord Hunt, those being the submissions to ministers, in particular Lord Owen and his successor. So that the first papers I'm going to ask you about. The second is in relation to Lord Owen's private papers. And the third is in relation to the ACVSB minutes and underlying documents that were contained within GEB files and in other places as well that you were involved in looking for as part of the hepatitis C litigation.
Mm-hmm.
So dealing first then with the papers that you had discovered were missing in October 2001 when you were preparing the chronology and submission for Lord Hunt as a result of the allegation being made by Lord Owen that the civil service had frustrated his pledge to Parliament about self-sufficiency. And you've already told us a little bit about that. It's right to understand, is it, that you were looking at this stage at official or registered files, were you?
Correct.
Can you just tell us what the difference is between official files or are they called are they registered files or official files? What's the
registered files?
Registered
I guess,
files.
Yes.
What's the difference between registered files and private papers?
Department of Health officials, like any government department officials, are expected to keep a very clear audit trail of all decisions made, and those decisions in those, until the early 2000s were all on paper files. So you would go into a paper file and you would find a succession of minutes and submissions and briefings and papers that would give you a complete story, if you like, about what happened. And it was the responsibility of people working on a policy issue to make sure that all the relevant papers were put on a registered file. And by registered, I mean a file which would then go into the departmental archives once the issue had been addressed. So it would have a number that it was given, and it would then, in theory, you should be able to look back and find all the information about that particular issue. Most offices at that stage had a whole series of filing cabinets full of registered files, so you could look back and see what was available. Periodically, the files were sent back to the central records unit and might have to be retrieved from there. And in this case, I can't remember whether we already had the files in the office or whether I had to send off for them. And you asked me the difference between private papers. Individuals might well keep their own sets of papers. That's more likely to be senior people or ministers. So if you were anybody who was the chair of an expert committee, for example, might well have hung on to the papers that they were sent for that expert committee. And there was no reason why they shouldn't do that. The issue with ministers is a little different, and I don't know how often ministers would keep back, the papers they'd looked at. If they were planning to write their memoirs or whatever. It clearly happened. So that's the distinction, that the registered file should contain the official record of all the decisions made. There shouldn't be anything contained in private papers that is not also on the registered file, and I think that's an important point.
And are there other categories of papers? So could you have registered files and then another category of paper?
No, I don't think so.
So all correspondence would be in the registered file?
All correspondence should be on the registered file,
all
absolutely.
Legal advice?
Yes. There was, I think, I remember back in the 70s when everything was handwritten and sent to type-in pools. To be honest, those files were kept in a lot better condition than they were later. There was a very strict process where you would handwrite all the minutes and the notes and records of telephone conversations, etc., on the left-hand side of the file, and on the right hand would be all the briefings and submissions and decision papers. And those were usually wonderfully kept. Once we got into email, I think the process got a lot more sloppy.
And what was the expectation once you get into email that you should print the email up and have it in the paper file? Initially, yes, and then we moved into electronic filing, which was another issue again. What did you have training or instruction on record keeping and filing? In the sense that, I mean, when I started in a much more junior role and was expected to make sure that files were upkept properly, then yes, it was part of the job to do that. So I certainly grew in my civil service career to know what a well-kept file should look like. And how about training about when you could destroy or throw away records, papers, emails, documents, anything of that sort? There was a guidance document produced by the department on management of registered files, which you included in the documents that you sent me, which I recollected. It was very long, and I suspect because it was so long that not everybody read it as well as they should have done. The process of sending files back to the register, usually with a docket that would say review in so many years or destroy or whatever, were usually delegated to junior members of staff, and the guidance was that those decisions would be taken at executive, well, the most senior sign-off would be at executive officer level, which is still fairly junior. So I suspect, I don't know, I suspect that there were some rather haphazard and inconsistent decisions on, well, there clearly were, on destruction of files. Was the expectation that all emails, notes of telephone calls, notes of meetings, letters, records would go onto the file, and then they would only be destroyed in accordance with the destruction policy that had been decided on for that file? Yes, I think there was a policy that if there was nothing new had gone onto that file about that particular issue for 5 years, say. I think it was 5 years, but I can't remember exactly. Then you could consider that file for destruction. And the expectation was that things wouldn't be thrown away before they got onto the file. People wouldn't be making decisions about, no, well, this isn't really relevant, I'm not going to put it... No, absolutely not. I think I've always thought that having a very clear audit trail of decisions is essential. Otherwise, you know, if you look back at them, you can never be clear about what happened. It wasn't always done as well as it should have been. You know, busy people neglected to do what they should have done a lot of the time, I think. And there wasn't always, when you have a team of people working on something from a branch head through to an executive officer, you know, who decides whose papers go on the file and how is that managed? And again, I'm not sure that process was always done as well as it should have been. But what you're describing is there was a process by which somebody made a decision about which papers should go on the file. So not everything would automatically go onto the file. There was a decision-making process about what should go onto the file. I think people got out of the habit of recording things like telephone conversations, though those tended to get missed. I think my experience, most of the essential material went on to
went onto files. What wasn't always as clear, I think, are those sort of missing bits in the middle. Why did we go from A to B to C? You've just got the documents, but not necessarily the information that leads you as to the, some of the questions you're asking me today about, why and what happened next.
And were there record managers and archivists working through your time in the civil service?
There was certainly records managers. I think, that for the paper files, there was the central records unit, and they were the people who issued the guidance as well. I don't recall any central review about what individual teams were doing. That happened more later on. I think when I went back to the department and there was a concern that there was inconsistency in the way that electronic records were being managed. At that point, there was record managers were trying to ensure that everybody was approaching electronic filing in the same way.
So, going back then to the papers that you discovered were missing from the registered files, that you would have expected to see from the 1970s dealing with self-sufficiency. Is it right to understand that you searched all the surviving files that you could find and didn't find these submissions?
That's correct.
And
just to be clear, I looked at only a couple of years, I suspect, of papers. So I tried to trace through what happened to the 500,000, etc., that Lord Owen provided, and where that money went and how it was spent, etc. So to try and answer the question about whether it was spent as it should have been on self-sufficiency, which I didn't go much beyond that.
So the missing documents you noticed would have been in relation to that issue?
It was recognising that there would have been points at which officials would have given ministers an update. And they clearly did, because later on, Roland Moyle gave an update to the House of Commons, as well as writing to the Haemophilia Society, saying what had happened about the funding on self-sufficiency. So that communication with ministers was clearly happening, but the evidence of that was not on the files.
And your statement tells us, and I think you told us earlier today, that you were told that the files had been provided to the solicitors. Is that right? Or
I can't remember how I came to that conclusion. Somebody might have suggested to me, Mike McGovern might have suggested to me that that's what had happened, and Anita James, I think, confirmed that they would have been taken out of the files for public interest immunity as part of the HIV litigation disclosure earlier in the 90s. But then the solicitors division didn't have them any longer, or weren't able to find them.
Is this right, that if you were taking documents off a registered file in order to provide them to the solicitors for a disclosure exercise in litigation, you would be expected to take copies?
They should have done, yes, absolutely.
So I'm just trying to understand whether you think you were told by somebody that is what happened to them, or whether that's what you think must have happened to them because they're not on the file and that's the most likely explanation.
My memory is of being totally convinced that that's what happened to them, but I can't remember what convinced me. And I do recall badgering Anita James and her people on several occasions to search for them, see what happened, if they could find them. because it seemed to me, as part of the chronology I was providing to ministers that we wanted then to pass on to the Haemophilia Society and others, that it was really important to have those.
And then, as to what happened to the files once they'd gone to the solicitor, is this right, that it's really supposition when you say, well, that they were destroyed in a clear out by the solicitor? You don't know that, but that's supposition, but you think that's the most likely explanation?
That is supposition. And again, I think somebody might have suggested, oh, this could have happened in the solicitor's branch. So, yes, I drew a complete blank and gave up in the end. And
to be clear, did you play any part in the HIV litigation and the decisions made at that time to take documents off the file?
No, entirely before my time. I was working on other things then.
Can I then turn to Lord Owen's private papers? We heard this morning that you spent some time in private office.
Mm-hmm.
Can you tell us what the practice was during your time at the civil service for dealing with a minister's private papers when there was a change of government?
Well, ministers' private offices would keep all the copies of anything that had gone into the minister, so submissions from officials, cabinet papers, etc. But there's a convention a long-standing convention within government that if you have a change of government, then the new set of ministers are not allowed to see the documents provided to their predecessors. And certainly when I was in private office, and this would have been at the 1974 election, there were two that year, I certainly remember having a clear out of documents as part of the general procedure. So you would wait. There is guidance issued by Cabinet Office about what to do in the event of general elections, which includes what to do about papers from the previous administration, and usually you obviously have to wait to know what the result of the election is, because it might be the same administration returning, in which case you don't do anything. If it's a complete change of administration, then you need to dispose of cabinet papers, etc., that have been held by you. Now, what I've never been quite clear about, to be honest, is what Lord Owen means by his private papers. So I must sort of give that particular caveat there. So when ministers are sent submissions by officials, they will usually go into a ministerial box, and the minister will, often with a note from the private secretary, and the minister will write something in return, either to say they agree or disagree, and to make some other comment. So there will sometimes be annotated submissions by ministers, but not always, because they might write on the note that the private secretary appended. The private secretary will then relay that back to the officials, these days with an email saying, the minister has said X and Y, and we've got plenty of examples in the disclosure documents here. Sometimes, very occasionally, you'd get the minister's actual annotated comments back. But probably more often than not, those would be kept by the private office. And then on a change of government, those would probably be shredded in line with the usual convention. It shouldn't be the case that anything that a private office disposes of should be available elsewhere. So if we're talking about submissions, those should be on the registered file in the policy area. So private office disposing of them is not getting rid of that particular evidence. But I guess what it might do, what you might lose, are the annotated comments from ministers, unless a private secretary thinks, oh, this is so important, I better shunt this back to officials.
And so just to be clear, that the clear out of the private papers is nothing to do with the registered files. These are the private papers kept by the private office of the minister.
Yes.
And you've described it as a convention that this was done on the change of a government. Mm-hmm. Was that, as far as you're aware, widely applied on changes of government?
Yes, it's part of the Cabinet Office guidance. So it applies across all government departments.
And can you recall when you were involved in this process whether you would have carried out checks before destroying the private papers to make sure that those submissions and documents and so on were replicated in the
I'm afraid I was very, very, very junior back in 1974, and I would have just been handed a pile of stuff and told to shred it. But I think quite often, I mean, instead of... So things like cabinet papers, I think, would certainly just be shredded by private office. But think copies of submissions or folders about a particular policy issue, the private office might just decide to send that back. I'm sure I can recall, for example, when I worked on HIV, which I was still doing in '97 at the change of government, having stuff sent back to me in folders from private office and then checking to see if it was a duplicate of things I had already.
Is there any direct evidence you can give to the inquiry about what happened to Lord Owen's private papers?
No.
I'm going to turn now then to the third category of papers or documents, and that is the ACVSB, the Advisory Committee on the Virological Safety of Blood papers, consisting of minutes and background papers. Mm-hmm. And ask you some questions in relation to those. So is it right to understand that you first became involved in trying to find these missing papers when Ms. James, a solicitor, explained to you by email that she was minded to agree to disclose relevant documents in the hepatitis C litigation, even though the Department of Health wasn't a party to that litigation?
Mm-hmm. Yeah, I mean, at that stage, I wasn't aware that we were talking about missing documents. This was a disclosure exercise, and I assumed that we would find them quite easily.
And this was in November 1999, was it?
Yes.
And perhaps and so you were asked, is this right, you were effectively tasked by Ms. James to find the documents that she wanted to disclose that she thought were held by your directorate?
Yes.
Why were you tasked with that? Why you?
Because the papers would be held by our team.
So it was because the papers should have come from your team, or should have been by your team?
Yes, yes. I mean, either as registered files which we could retrieve, or from other documents we had in the office. So, for example, Andre Raymond, who had chaired the ACVSB, had retired, but Mike McGovern, I think, who had taken over from him, still had some of Andre's old papers.
And So you said that at first you didn't realise that they were the files were missing, or at least that it was going to be difficult to find them. What subsequently happened?
Yes, I'm trying to remember again the sequence of events is in my written statement. Would it be possible to have that? My screen has gone blank, by the way. I don't know if it should have done.
Well, let me ask you, because we're just about coming up to break, so I'll ask you some questions that don't involve looking at documents, and perhaps we can sort your screen out at the break. The first the first question I wanted to ask you was this: that we learnt from the evidence of Dr. Raymond that some of these documents were on a file called GEB, which he thought was general blood. Does that ring a bell with you? Are you able to assist us with that?
I am not. I think there's a reference to GEB in my evidence because it comes up in the papers. And to be honest, I've completely forgotten what it stood for, so that's...
So I wonder whether we could take a break now so that we can sort out...
Well, that sounds very sensible. So let's take a break now until 20 to 4. 20 to 4.